A femme covert cannot take anything of the gift of her husband, except by will or through the medium of uses and trusts, but she is of capacity to purchase of others without the consent of her husband, and of this opinion was Littleton in the Yearbooks, and in this book, section 677. But her husband may disagree thereunto and divest the whole estate, but if he neither agree nor disagree, the purchase is good. But after his death, albeit her husband agreed thereunto, yet she may, without any cause alleged, waive the same, and so may her heirs also. If after the decease of her husband she herself agreed not thereunto, a wife, uxor, is a good name of purchase, without a Christian name, and so it is if a Christian name be added and mistaken, as M for Emmeline, etc. For utile per inutile non fituator. But the Queen Consort of the King of England is a separate person from the King by the common law, and is of ability and hath a capacity to purchase and grant without the King, of which see more at large, section 200. The parishioners, inhabitants, or churchwardens of parish are not, as such, capable of purchasing lands, except by an act of Parliament or grant from the Crown, but goods they may purchase. An ancient grant by a lord to his commoners of a right of way was formerly good, but otherwise it is of such a grant at this day. And so in ancient time a grant made to a lord, et hominibus su tam liberis quam nativis, or the like, was good, but these persons are not of capacity to purchase land by such a name at this day. And regularly it is requisite that the purchaser be named by the name of baptism and his surname, and that special heed be taken to the name of baptism, for a man cannot have two names of baptism, but he may have diverse surnames. And yet in some cases, though the name of baptism be mistaken, as in the case put before of the wife, the grant is good. So it is if lands be given to Robert Earl of Pembroke, where his name is Henry, to George Bishop of Norwich, where his name is John, in these and the like cases there can be but one of that dignity or name, and therefore such a grant is good, albeit the name of baptism be mistaken. If the licensed lands be given to the Dean and Chapter of the Holy and Undivided Trinity of Norwich, this is good, although the Dean be not named by his proper name, provided there be a Dean at the time of the grant. For the Dean is the head, and without a head the corporation is not complete and cannot purchase. But in pleading the Dean's proper name must be shown. And so on the other side, if the Dean and Chapter make a lease, without naming the Dean by his proper name, the lease is good. If there were a Dean at the time of the lease, but in pleading the proper name must be shown, and so is the Yearbook 18E4 to be intended, for the same judges in 13E4 held a grant to a mayor, alderman, and commonalty to be good, although the mayor was not named by his proper name, but in pleading the name must be shown, as it was there also holden. If a man be baptized by the name of Thomas, and after, at his confirmation by the bishop, he is named John, he may purchase by the name of his confirmation. And this was the case of Sir Francis Gaudy, late Chief Justice of the Court of Common Pleas, whose name of baptism was Thomas, and his name of confirmation Francis. And the name of Francis he afterwards bore, and by the advice of the judges used that name in all his subsequent purchases and grants. And this agrees with our ancient books, where it is holden that a man may have diverse names at diverse times, but not diverse Christian names. And the court said, it may be that a woman is baptized by the name of Annabel, and 40 years after she is confirmed by the name of Douce, and then her name is changed, and after she is to be called Douce. But all purchases, etc., made by her name of baptism before her confirmation remain good, a matter not much in use now, not requisite to be put in use, yet it is necessary to be known. But purchases are good in many cases by a known name, or by a certain description of the person without either surname or name of baptism, as uxori J.S. as hath been said, or primo genito filio, or secundo genito filio, etc., or filio natu minimo J.S., or seniori puero, or omnibus filiis, or filiabus J.S., or omnibus labiris su excitibus, or J.S., or to the right heirs of J.S. A bastard having acquired a name by reputation may purchase by his reputed or known name to him and his heirs, although he can have no heir but of his body. A man makes a lease to B for life, remainder to the eldest issue male of B, and the heirs males of his body. B has issue a bastard son. He shall not take the remainder, because in law he is not his son. Forque ex damnato coitu nascontur inter liberos non computentur. And as Littleton says, a bastard is quasi nullius filius, and cannot have a name of reputation immediately on his birth. So it is if a man make a lease for life to B, the remainder to the eldest issue male of B, to be begotten of the body of J.S., whether the same issue be legitimate or illegitimate. B has issue a bastard on the body of J.S., this son or issue shall not take the remainder, for, as it has been said, by the name of the issue, if there had been no other words he could not take, and, as it has also been said, a bastard cannot take but after he has gained a name by reputation, as that he is the son of B, etc. Then if an estate be limited or given to him by that name he may take. Hence a bastard can take no remainder limited before he be born, but after he is born and has gained by time a reputation to be known by the name of a son, then a remainder limited to him by the name of the son of his reputed father is good. But if he cannot take the remainder by the name of issue at the time when he is born, he shall never take it at all. And so it seems, for the same cause, that if, after the birth of issue, B had married J.S., whereby the issue might have become bastard and have had a possibility to inherit, yet he shall not take the remainder. Persons deformed, having human shape, idiots, madmen, lepers, deaf, dumb, and blind, minors, and all other reasonable creatures, have power to purchase and retain lands or tenements. But the common law disables some men to take any estate in some particular things, as if an office either of the grant of the king or subject, which concerns the administration, proceeding, or execution of justice, or the king's revenue, or the commonwealth, or the interest, benefit, or safety of the subject, or the like, if these or any of them be granted to a man that is inexpert, and has no skill and science to exercise or execute the same, the grant is merely void, and the party disabled by law and incapable to take the same pro commodo regis populi. For only men of skill, knowledge, and ability to exercise the office are capable of the same, to serve the king and his people. An infant or minor is not capable of an office or of stewardship of the court of a manor, either in possession or reversion. No man, though never so skilful and expert, is capable of judicial office in reversion, but must expect until it fall in possession. And see section 378, where bargaining or giving of money or any manner of reward, etc., for offices there mentioned, shall make such a purchaser incapable thereof, which is worthy to be known, but more worthy to be put in due execution. A monster born within lawful matrimony, that have not human shape, cannot purchase, much less retain anything. The same law is de professis et mortuis seculo, for they are civilita mortu, whereof you shall read at large in its proper place at section 200.